All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
On December 16, 2020, Congressman Ferdinand L. Hernandez of the 2nd District of South Cotabato filed a complaint for cyber libel under Republic Act No. 10175 or the Cybercrime Prevention Act of 2012 against then-lawyer Berteni Causing before the Office of the City Prosecutor of Quezon City. Hernandez claimed that on February 4, 2019 and April 29, 2019, Causing uploaded posts on the social media platform Facebook which made it appear that Hernandez stole public funds intended for Marawi siege victims. Hernandez further claimed that Causing's Facebook post maligned and discredited him by portraying him as a thief unworthy of trust and public office. After a finding of probable cause, the city prosecutor filed two separate informations before the regional trial court charging Causing with 2 counts of cyber libel under Section 4C4 of the Cybercrime Prevention Act of 2012 in relation to Articles 353 and 355 of the Revised Penal Code. Arguing that the charges had already prescribed since they were filed more than a year after the Facebook post, Causing filed a motion to quash the informations, which the trial court denied. This prompted Causing to elevate his case to the Supreme Court. This leads us to the question, what is the specific time frame within which a case for cyber libel should be filed? On what law should the prescriptive period for cyber libel be based? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 3rd of October 2025, and today we talk about cyber libel, which is commonly referred to as online libel. Within the context of the case of Berteni Catalonia Causing versus People of the Philippines, GR number 258524, penned by Associate Justice Henry John Paul Bienting, this case was decided by the Supreme Court on October 11, 2023. And joining us to discuss this today is Court of Appeals Associate Justice Wilhelmina Jorge Wagan, a member of the Supreme Court Special Committee on Cybercrime and Electronic Evidence, and a professorial lecturer at the Philippine Judicial Academy. Hi, Justice Wagan. Welcome to the Supreme Court Podcast, and thank you for having us here in your chambers at the Court of Appeals.
Hello, Attorney Mike. It's my pleasure to have you here.
All right. So, Justice, just to get the discussion started, let's briefly discuss this concept of cyber libel. What makes it different from the concept of libel, which we traditionally know from the Revised Penal Code?
All right. Cyber libel, as defined in Section 4C4 of Republic Act 10175, or the Cybercrime Prevention Act of 2012, refers to the acts of libel committed through a computer system or any similar means that may be developed in the future. RA 10175 essentially extends the traditional concept of libel outlined in Article 355 of the Revised Penal Code to the digital realm. In Decini v. Secretary of Justice and reiterated in Causing v. People, cyber libel is not a new and or distinct crime. RA 10175 merely provides another means of committing libel, specifically through digital platforms. In essence, cyber libel, or commonly referred to as online libel, is defamation committed through a computer system or digital platforms such as Facebook, Twitter, blogs, online posts, or comments. While libel under the Revised Penal Code is defamation through writing, print, or other physical media.
Mm-hmm. And Justice, because this is still libel, the elements of identification and malice will still be required.
Yes, correct. Mm-hmm. Correct. Attorney Mike, in fact, the essential element of defamatory imputation is important.
Mm-hmm. All right. And what are the penalties imposable on a person convicted of cyber libel? How do these compare to those on libel under the RPC?
Under RA 10175, cyber libel carries a heavier penalty compared to libel under the RPC. The penalty for cyber libel is 1 degree higher than what's prescribed for libel under the Revised Penal Code. Libel under Article 355 of the Revised Penal Code is punishable by imprisonment ranging from 6 months and 1 day to 4 years and 2 months. There's also the option of a fine, which can range from 40,000 pesos to 1.2 million. In some cases, both imprisonment and fine. Because cyber libel carries a penalty of 1 degree higher than libel under the RPC, the potential jail term is notably longer, ranging from 4 years, 2 months, and 1 day, up to 8 years of imprisonment. So when it comes to fines, it can reach as high as 1.5 million. So if someone commits cyber libel, say through social media or a blog, the legal consequences are more severe than if it were done through print or other offline means.
Justice, for the information of our listeners, cyber libel is only one of the crimes covered by RA 10175 or the Cybercrime Prevention Act of 2012. Can you walk us through some of the offenses under the said act that are punishable?
Okay, yes, Attorney Mike. Cyber libel is just one of the offenses defined under RA 10175. The law defines a wide range of online offenses classified into core cyber crimes and cyber-enabled crimes. The core cyber crimes are outlined in sections 4 and 5 of the law. Section 4 classifies these offenses into 3 distinct categories: offenses against confidentiality, integrity, and availability of computer data and systems, computer-related offenses, and content-related offense. The first category, concerning offenses against confidentiality, integrity, and availability of computer data and systems, include illegal access, illegal interception, data and system interference, misuse of devices, and cyber squatting. The second category covers computer-related forgery, fraud, and identity theft. When it comes to content-related offenses, it's worth noting that as things stand, only cyber libel remains punishable. This is due to the Supreme Court's decision in Decini versus Secretary of Justice, which struck down the provision on unsolicited commercial communications as unconstitutional. Also, the provisions on cybersex and child pornography under RA 10175, when committed through a computer system, have been expressly repealed by Republic Act 11930, or the Anti-Online Sexual Abuse and Exploitation of Children, o SAEC, and Child Sexual Abuse and Exploitation Material, or CSAM. As a result, cyber libel now stands as the only content-related offense under the cybercrime law. Section 5 of this law, on the other hand, addresses acts such as aiding, abetting, the commission of any cybercrime, as well as attempts to commit such offenses. The penalty imposable, however, is 1 degree lower than that prescribed for the principal offense. Section 6 expands the scope of the law by providing that all crimes defined under the revised penal code and special laws, when committed by, through, and with the use of information and communications technology, shall likewise be punishable as cybercrime under RA 10175. So in such instances, the penalty is higher by 1 degree than that prescribed by the RPC or the special law.
Which is exactly the situation with cyber libel.
Yes.
As vis-a-vis libel in the RPC. So, Justice, let's go to the case of Kausing versus People. What prompted Representative Hernandez to file a cyber libel complaint against Kausing? What was the basis?
The Facebook posts of Kausing, it concerned over alleged irregularities on how funds meant for the Marawi siege victims were managed.
So, Kausing tried to have this case dismissed by filing a motion to quash.
Yes, correct, Attorney Mike.
How did the trial court rule, and what was the basis of the trial court for denying the motion to quash?
The RTC denied Kausing's motion to quash, ruling that the prescriptive periods of crimes under Article 90 of the Revised Penal Code does not apply. Ruling that the prescriptive periods of crimes under Article 90 of the Revised Penal Code does not apply to cyber libel under RA 10175, as the provisions of the RPC only suppletorily apply to special laws. The trial court ruled that since RA 10175 does not provide a specific prescriptive period, the provisions of Act 3326 shall apply. And given that the penalty for cyber libel under RA 10175 in relation to Article 355 of the Revised Penal Code is 1 degree higher, that would be from 4 years, 2 months, and 1 day to 8 years, the Regional Trial Court applied the 12-year prescriptive period under Act 3326 and concluded that the cyber libel charges against Kausing have not prescribed. The complaints were filed less than 2 years after the alleged defamatory content was uploaded on February 4, 2019 and April 29, 2019.
And Justice, why is the issue of timeline in the filing of the case significant in this case? I note that you just mentioned the posts were made February 4, 2019 and April 29, 2019. But the filing of the complaint with the prosecutor took place in December 2020. So going by Kausing's argument, it's more than 1 year. But if we go by the RTC's argument, Representative Fernandez can still file it because it's within the 12-year prescriptive period. So the issue of timeline, how significant is that?
It is significant because it will determine if the complaints were actually filed within the prescriptive period. The prescriptive period sets the time limit for prosecution of offenses.
So in short, if you go beyond the prescriptive period, you cannot file the case.
Yes, you're right, Attorney Mike.
All right. So what was Kausing's argument regarding prescriptive period or prescription under Article 90 of the Revised Penal Code?
Kausing contended that the cyber libel charges should be dismissed for being time-barred, arguing that the offense prescribes in 1 year, invoking Article 90 of the RPC. He also cited the ruling in Decini versus Secretary of Justice and insisted that RA 10175 did not create a new crime but merely increased the penalty and provided a qualifying circumstance for libel committed online. So if his contention is correct, this would extinguish his criminal liability.
And Justice, how did the Supreme Court finally resolve that issue, the issue of prescriptive period in cyber libel? So is it 12 years? Is it 1 year?
So in Kausing versus People, the Supreme Court ruled that cyber libel as defined in Section 4C4 of 10175 is simply the same libel under Article 355 of the Revised Penal Code committed through a computer system. The Supreme Court in Decini and reaffirmed in Kausing clarified that this is not a new crime but the same offense with information and communication technology use treated as a qualifying circumstance. So given this interpretation, the court applied the 1-year prescriptive period under Article 90, Paragraph 4 of the Revised Penal Code, which is more favorable to the accused than the 12-year period under Act 3326. This effectively overturned the ruling in Tolentino versus People, where a 15-year prescriptive period had been used.
So Justice, clearly the prescriptive period for cyber libel is 1 year, but counted from when? When does the prescriptive period start?
All right, Attorney Mike, that's a good question because that's one of the issues that was resolved by the Supreme Court. The Supreme Court clarified that cyber libel follows the same legal standards as ordinary libel under Article 355 of the RPC. And the prescriptive periods as well as the procedural rules like reckoning from the date of the discovery apply equally to cyber libel. So it prevents double jeopardy, harsher treatment simply because the defamatory content was published online. In short, the law modernizes libel enforcement without altering its legal essence.
And there were cases that were discussed by the Supreme Court. So the Supreme Court had several decisions prior to this ruling which discussed different prescriptive periods.
Yes, Attorney Mike.
And it also discussed when the prescriptive period starts.
Yes. So in Kausing, the Supreme Court cited several decisions regarding when the 1-year prescriptive period of libel, including cyber libel, begins. So this applies to both online libel and libel as defined under the Revised Penal Code. The Supreme Court pointed out decisions which touch on the date of discovery of the defamatory remarks. In Alcantara versus Amoranto, the prescriptive period commenced from the date the offended party discovers the libelous content. The court emphasized that a person cannot be expected to file a case without knowing they were defamed. In Enchong versus Tolentino, similarly, the court ruled that the prescriptive period begins upon receipt or discovery of the libelous material by the offended party. However, the cases of People versus Hines and Sin Hon Leong versus Rivera considered the date of publication as a starting point. In People versus Hines, the court counted the prescriptive period from the date of publication, but it noted that this aligns with Article 91 only if the publication date is also the date of discovery. In Sin Hon Leong versus Rivera, the period was reckoned from the date a libelous text message was sent, as there was no later discovery date that was alleged. The Supreme Court also cited other cases using publication date. In the case of Calderon Vargas versus the RTC of Pasig, as well as in Arambulo versus Honorable Lucky, both cases used the publication date or circulation date as the starting point, implying that discovery occurred simultaneously.
So if it's not clear when it was discovered, it's
Yes.
presumed that it's on the date of publication.
Yes.
Right? So in this case, in Kaohsing, was there an allegation when supposedly the defamatory material on Facebook was discovered?
In this case, in the case of Kaohsing, Representative Hernandez did not categorically state in his complaint affidavit as to when did he discover the Facebook posts. He simply stated that he discovered it just weeks prior to the filing of the complaint affidavit on December
2020.
16, 2020.
All right. So in this case, Justice, it seems that on the basis of arguments, Kaohsing won. But the Supreme Court eventually denied his petition, questioning the denial of his motion to quash by the RTC. Why is that?
The Supreme Court denied Kaohsing's petition for certiorari, ruling that despite the RTC's erroneous application of the laws to determine the period of prescription of cyber libel, it was nevertheless correct in denying the motion to quash, meaning the RTC was correct in denying the motion to quash. However, the Supreme Court further discussed that prescription is a matter of defense, and the prosecution need not even anticipate or meet it in the information. Unless prescription is apparent on the face of the information, the accused bears the burden to prove that the crime has prescribed. Thus, the Supreme Court concluded the matter of prescription requires the presentation of evidence, and whenever necessary, the trial court must set a hearing on this issue.
So that's why the case is still pending. It was not actually dismissed by the court, despite the arguments of Mr. Kaohsing.
Yes, actually, the contents of the order was simply his motion to quash was denied because the crimes did not prescribe and set the case for arraignment and pre-trial. So the case actually proceeded.
In terms of the broader implications, Justice, of this decision, can you share with us what are your thoughts about this ruling? Because I understand this is the first time that the Supreme Court has ruled that the prescriptive period for cyber libel is the same as libel, 1 year. What are we looking at?
This has broad implications. I agree with you, Attorney Mike. It protects free speech by preventing indefinite liability for online posts. It strengthens accountability by allowing victims to seek justice even after delayed discovery, and brings legal clarity to the evolving digital landscape by aligning cyber offenses with traditional libel standards.
And in closing, Justice, what should be our listeners' key takeaway from this case, especially those who often post their sentiments online to social media? So what should they keep in mind?
Yes, Attorney Mike. The key takeaway for me from the ruling in the case of Kaohsing is that the Supreme Court reaffirmed that only Congress, not the court, can change the prescriptive period or the criminalization of libel and cyber libel. While the court acknowledged debates on whether libel should remain a crime, given free speech and democratic values, it emphasized that as long as criminal libel exists in the revised penal code and RA 10175, the judiciary must apply the law as written, leaving any room for any reform or decriminalization to the legislature. While freedom of expression and political criticism are strongly protected in a democracy, social media users should exercise caution. Critical speech is allowed, but defamatory lies remain punishable. So they must think before they click.
Right. So many instances comes to mind with that reminder. So thank you so much for joining us today, Justice Wagan.
I also enjoyed talking to you, Attorney Mike. Thank you.
And we will see you again for next week's episode. And to our listeners, if you wish to read the full text of the decision of the Supreme Court, please visit the Supreme Court website, sc.judiciary.gov.ph, and search for GR number 258524, Bertani Kausing versus People of the Philippines. Here's Steph Atendido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court en banc on Tuesday, September 30, 2025, declared unconstitutional two laws enacted by the Bangsamoro Parliamentary, which drew and redrew districts in the Bangsamoro Autonomous Region in Muslim Mindanao, or BARM. The SC struck down Bangsamoro Autonomy Act No. 77 and permanently stopped its enforcement because it violated the Voters Registration Act, which prohibits any change in precincts once the election period has started. BAA 77 was signed into law on August 28, 2025, or after the election period started on August 14. BAA 77 reallocated districts originally intended for Sulu to other BARM provinces after the Supreme Court declared Sulu not part of BARM. BAA 77 also violated the Bangsamoro Organic Law because some districts are neither contiguous nor adjacent. The Supreme Court also voided BAA 58, BAA 77's predecessor, because it is based on an outdated framework with Sulu still part of BARM. Instead, the High Court held a new and valid districting law must be passed. In view of the ruling, the SC declared there can be no BARM parliamentary elections on August 13. Instead, it directed COMELEC to prepare for and hold the Bangsamoro parliamentary elections not later than March 31, 2026. Meanwhile, the SC has approved the 2025 transitory rules on electronic filing and service in the Supreme Court under AM number 25-09-16-SC. Starting October 30, 2025, the exclusive mode of filing and service of pleadings, motions, and other papers in the SC and court-issued documents in covered cases and among covered filers shall be through the eCourt PH app. The SC has also extended the period for the hybrid digital filing of pleadings under AM number 25-05-16-SC in the SC until October 29, 2025. In another decision, the SC has revised Rule 140 of the Rules of Court to introduce fairer penalties for habitual tardiness among judiciary personnel, ensuring the sanctions are proportionate to the actual impact of the offense. The court en banc, through the ponentia of Associate Justice Alfredo Benjamin Caguiwa, approved amendments to Rule 140. Under the latest amendment, judiciary personnel may now be held liable for either a light charge for ordinary habitual tardiness that does not disrupt office functions, or a less serious charge of habitual tardiness if it does, depending on the circumstances. The amendment also redefines the previous less serious charge of habitual absenteeism and/or tardiness to now read as habitual tardiness causing prejudice to the operations of the office and/or habitual absenteeism. The SC has clarified that domestic market enterprises can enjoy the zero-rated value-added tax or VAT incentive under Republic Act No. 115334 or the Corporate Recovery and Tax Incentives for Enterprises or CREATE Act. In a panensya by then Associate Justice Maria Lopez, the SC en banc declared Rule 18, Section 5 of the Implementing Rules and Regulations or IRR of the CREATE Act and several Bureau of Internal Revenue or BIR issuances void for unlawfully limiting which businesses could avail of the VAT incentive. The SC ruled that the IRR and the BIR regulations were invalid for adding restrictions not found in the CREATE Act, as the law clearly covers all registered business enterprises, including domestic market enterprises. The SC emphasized that government agencies like the Department of Trade and Industry and Department of Finance cannot go beyond what the law allows. On Monday and Tuesday, the SC held the 6th National Family Courts Summit in Makati City through the Committee on Family Courts and Juvenile Concerns, or CFCJC, co-chaired by SC Associate Justices Ami Lazar Javier and Josep Lopez. Addressing family court judges, Acting Chief Justice Marvic Leonan emphasized that our voices in our rulings should reflect the understanding we have of our people, not just a few of its dominant voices. CFCJC Vice Chairperson Court of Appeals or CA Associate Justice Geraldine Fial Macaraig also introduced the Benchbook on Judicial Forms for Family Courts, which provides family court judges with digital templates of various forms. Among the speakers and lecturers were retired Chief Justice Teresita Leonardo de Castro, Federal Circuit Court of Australia Justice Alistair McNabb, Singapore Family Court Judges Kenneth Yap and Carol Liu, and Social Welfare and Development Secretary Rex Gatchalian. Several justices from the Court of Appeals and Sandigan Bayan also spoke during the conference, as well as judges who are members of the committee. The conference served as a venue for around 500 family court judges from across the country to discuss and share knowledge on different topics and recent developments on family law, family mediation, and digitalization in the adjudication process. In another convention, Associate Justice Ramon Paul Hernando reiterated to judges that judicial excellence can be achieved through competence, compassion, and courage. Speaking at the Philippine Judges Association, or PJA Midterm Convention and Seminar in Pasay City, Justice Hernando emphasized the need to embrace changes and enhance their skills as he discussed the court's ongoing efforts to modernize and digitize court processes under the Strategic Plan for Judicial Innovations 2022 to 2027. Acting Chief Justice Marvic Leonan, working chairperson of the SC Committee on Computerization and Library, shared digital transformation efforts of the Philippine judicial system, while SC Associate Justice Rodil Zalameda discussed the 2025 revised rules on criminal procedure. Associate Justice Maria Filomena Singh also spoke on the 2025 proposed amendments to the Rules of Civil Procedure and the revised Code of Judicial Conduct. Finally, the SC announced that the 2026 Sharia Special Bar Examinations will be held on May 24 and 27, 2026. Applications will be accepted from December 1 to 12, 2025 and must be filed through the Barista app. Further details, including application requirements and procedures, will be released in forthcoming bar bulletins. You are now up to date with the Philippine Supreme Court. I am Tifatan Tran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, May Sibal, and Ramir Christopher Simbahon as researchers, Brian Austria, Don Ryan Balza, Lawrence Olanio, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.